Appendix A. The Honorable Josiah G. Abbott, LL.D. Draft of the address prepared for the minority of the Electoral Commission of 1877. In this instance the minority was the Democratic Party, even though the Democratic Party controlled the House of Representatives. There were 7 Democrats and 8 Republicans, which gave the deciding vote to Hayes to steal the election from Samuel Tilden by 1 electoral vote. Address of and by the Honorable Josiah G. Abbott, LL.D., Massachusetts, House of Representatives and a member of the Electoral Commission. To the people of the United States, the minority of the Joint Commission established by the Act of Congress of January 27, 1877, to decide questions arising in the count of the electoral votes, desire to address the people of the whole country on the subjects submitted to and decided by that commission. No more important questions can ever come before any tribunal or people for consideration and determination. Upon their determination depends who shall be president of this country, whether he shall owe that great office to the free, honest choice of the people, or to bribery, forgery, and gross fraud. The minority of that commission, by the law establishing it, had no opportunity of reporting the reasons for their action to the 2 houses of Congress. The presence of a stenographer at these consultations was denied, so that record thereof exists. No way is open to those who did not join in, but on the contrary protested against, the decisions of the Commission, to make public their protest except by this address. The returns of the electoral vote of 4 states, Florida, Louisiana, Oregon, and South Carolina, were submitted to and decided upon by the Commission. Florida. In the case of Florida there were 3 certificates. The first, signed by the governor, certified that the 4 Hayes electors were elected according to the law of Florida and the acts of Congress. The second was signed by the Attorney General, and the third by the governor elected on the 7th of November last, both certified the election of the Tilden electors. The Attorney General was one of the 3 persons first canvassing the votes. To the third certificate were attached certified copies of all the returns of votes from every precinct in the state, which were originally made to the Secretary of the State, together with an act of the legislature providing for a new canvass of the vote according to the law as it had been decided by the Supreme Court, and the result of the new canvass thus ordered. It was offered to be proved, and it was not denied that such was the fact that by counting all the votes returned to the Secretary of State, according to law of Florida as expounded by the Supreme Court, the Tilden electors had been duly elected. It was offered to be proved, and was not denied, that the Tilden electors commenced proceedings in quo warranto, defined, a hearing to determine by what authority someone has an office or franchise or liberty, against the Hayes electors in the court of that state having jurisdiction by its constitution, notice of which was served on the latter before they gave their votes, and as soon as they were declared elected, and which was prosecuted to this judgment: that the Hayes electors had not been elected and had no title to the office, but that the Tilden electors had legally elected and were entitled to the office. It was offered to be proved, and was not denied, that the 2 canvassers who had made the certificate of election of the Hayes electors, which by the law of Florida was made on prima facie evidence, had erred in their construction of the law and exceeded their jurisdiction by so doing, in their canvass of votes on which the certificate was based. Thus it was offered to be proved, and the facts were not denied, that the governor's certificate given to the Hayes electors was false, and that the determination and certificate of 2 of the 3 who made the board of canvassers was false in fact and in violation of the laws of Florida, and that in making it the 2 had exceeded their jurisdiction. It was offered to be proved that the Supreme Court of Florida had, in effect, decided that the 2 canvassers had made a false certificate and exceeded their jurisdiction, and that the Circuit Court had so decided. It was offered to be proved that both the legislation and the executive of the state had so determined, and had attempted by all means in their power to prevent the state being defrauded of its true and real vote. The majority of the commission decided that the determination and certificate of 2 of a board of 3 canvassers, with ministerial powers only, and which by law was prima facie, not conclusive, evidence must stand and decide the great question of the presidency. Although it could clearly be proved to be false in fact, and that in making it the two canvassers had exceeded their jurisdiction and authority, as held by the Supreme Court of the state, and although the legislature and governor had both declared it false, and that by giving effect to it the state would be defrauded of its true and real vote, and although the electors, in whose favor it was made, had been declared by the courts not to have been elected. The injustice of the decision was the more marked and flagrant by contrast. All the state officers, from the governor down, who were voted for on the same ticket with the Tilden electors, and been counted out by the same two canvassers, at the same time, and by the same canvass by which the latter were counted out, had been declared elected by the action of the highest court of the state, and are now and have been holding their several offices to the general contentment of the citizens of Florida. But the Hayes electors alone are permitted by this decision to consummate the wrong, and act in offices to which they were never elected. Against this decision of the Commission the undersigned protested and now protest as wrong in law, bad in morals, and worse in the consequences which it entails on a great country. It gives absolute power to two inferior ministerial law of, relating to, or being a mandatory act or duty admitting of no personal discretion or judgment in its performance officers to withhold their determination till the day when the electoral vote is cast, as was done in this case, and then give the vote of a state to a candidate who has never received it, as was done in this case, and tells the people there is no redress, to set right, remedy or rectify, for such an outrage. It is the decision admirably calculated to encourage fraud, and ensure its being perpetrated with success and impunity, exemption from punishment, penalty, or harm. It is a decision by which the people of a state may be defrauded and robbed of their dearest rights by a few unprincipled wretches, and be then compelled to acquiesce in the great wrong. It is a decision claimed to be based on the doctrine of state rights, but, in fact, is in direct conflict with that great doctrine, for by it states and the people of states can be stripped of their rights and liberties, with no power to resist. We protest against the decision finally because by it the people of the whole United States are defrauded and cheated, because by it a person is put into it the great office of President, who has never been chosen according to the Constitution and law, and whose only title depends on the false and fraudulent certificate of two men in the state of Florida, instead of a majority of legal voices of the whole people, declared through and by their electoral college. Louisiana. In the case of Louisiana, the decision of a majority of the Commission is a stupendous wrong to the people of that state, and all the other states, and in defiance of all right, justice, law, and fair dealing among men. The law of that state establishes a returning board to consist of 5 persons of different parties, with power to fill vacancies, and to canvass and compile returns of votes from the different parishes and precincts, and declare the result. The board is given power and jurisdiction, provided affidavits are annexed to and received with the return from any precinct or parish, to inquire whether intimidation has existed, and if it is established to throw out the return for such parish, but this jurisdiction is carefully confined to cases where affidavits are attached to and returned with the returns of the votes. In no other case whatsoever is the power to reject votes given. It was offered to be proved, and was not denied, that the board giving the certificate to the Hayes electors consisted of 4 persons, all of the Republican Party, instead of the 5 persons of different parties, as required by law, that these 4 members had been requested by Democrats to fill the vacancy with a Democrat, but had uniformly refused to do so. It was offered to be proved, also, that this board of 4 persons, all of the Republican Party, in order to perpetrate the frauds with ease and impunity, employed 5 disreputable persons as clerks and assistants, all of whom had been convicted, or were under indictment, for various offenses, ranging from subornation of perjury up to murder. Indictment, at least, if not conviction, seemed the only admitted qualification of employment by that extraordinary board. It was offered to be proved, and was not denied, that this board, in order to give the certificate of election to the Hayes electors, had rejected 10,000 votes, and this was done, although not a return thrown out had been accompanied by the requisite affidavit to give jurisdiction to act at all. It was offered to be proved that the members of this returning board, in order to give the certificate to Hayes electors had resorted to and used affidavits known by them to be false and forged, had themselves been guilty of forgery, and had been paid for making their determination, thus adding bribery to the catalogue of their crimes. Numerous other corrupt and fraudulent practices were offered to be proved against the members of this returning board, among the least of which was a wicked conspiracy to rob the people of Louisiana of their rights and liberties. The decision of a majority of the Commission rejected all this evidence and held that the certificate of election given to the Hayes electors must stand, and could not be inquired into, if all such offers of proof could be substantiated. By that decision the people of the United States are told that the certificate of a board constituted in direct defiance of the law establishing it, and made by grasping a jurisdiction never granted to it, arrived at by forgery, perjury, wicked conspiracy, and the grossest frauds, and finally bought and paid for, must stand, and cannot be set aside, although steeped in sin and iniquity. It must make the chief magistrate of a great, free, and intelligent people. The undersigned protest against this decision, also, as bad law, worse in morals, and absolutely ruinous in its consequences. They denounce it in the presence of the people of the United States, and in the face of the world, because if intended and designed for such a purpose, it could not have been more cunningly contrived than it is to encourage the grossest frauds, conspiracies, and corruptions in the election of a president. They denounce it, because it will debase the national character, deaden the public conscience, and encourage fraud and corruption in all public and private transactions and business of the people. They denounce it, because for the first time it declares to the people by their organic law, the Constitution, it is ordained that a man may seek for, obtain, and hold this great office of Chief Magistrate of 42 millions of freemen by fraud and cheating. Nay, more, that he may openly buy the votes to elect himself, and pay down the price when the purchase is consummated by the count by the two houses of Congress, and call them to witness the payment, and that there is no help for it but revolution. They denounce it, because, in effect, it puts up the great office of President at auction, and says to the whole world that it may be bought in safety, and that there is no way known to man by which the title by purchase can be disputed or gainsaid, to declare false, deny. Oregon. In the Oregon case, a certificate signed by the Governor and Secretary of State, and under the Great Seal of the state, certified to the election of 2 Hayes and 1 Tilden elector. The 3 Hayes electors produced no certificate of election signed by any person, only a certificate of certain results, from which it was claimed that it could be inferred who were elected. The law of Oregon required a list of the persons elected to be signed by the Governor and Secretary of State, under the Great Seal, and this requirement, as well as that of the Acts of Congress, was fully met and satisfied by the first certificate. There was no certificate in the second case in any manner complying with the laws of Oregon or the Acts of Congress. Yet by the decision of the Commission the first certificate was rejected and the second taken, although clearly neither in conformity with state or federal law. The undersigned voted against counting the vote of the Tilden elector, because, notwithstanding the certificate of the Governor and Secretary of State, they were satisfied he had not been elected by the people of Oregon, and that his vote would not have been the true vote of that state. The majority of the Commission decided to set aside and reject the certificate and return, precisely the same in character that they had holden to be conclusive against all evidence in the Florida and Louisiana cases. They adopted and acted on a certificate insufficient if they regarded their former rulings, under any law, state or national. The undersigned denounced the Oregon decision as utterly at war with and reversing the rule established in the former 2 cases, and because it changes the law to meet the wants of the case, establishing different rules applicable to the same facts to bring about a desired result. In the Florida case, where the evidence failed to establish the fact, the majority of the Commission voted to receive evidence to prove 1 elector held an office of profit and trust under the United States when appointed. In the Louisiana case, where there was no doubt that the 2 electors held such office when appointed, it was voted not to receive evidence of the fact, because it was not offered to be proved that they continued to hold such offices where they voted. Apparently, the rules change as the requirements of the case change. South Carolina. In South Carolina, the undersigned voted against the Tilden electors being declared elected, because they had not received a majority of the votes of the people. In that case it was offered to be proved, in substance, that the United States troops in large numbers were sent to the state before the election, for the purpose of influencing and controlling the votes to be given thereat, by interfering with and overawing the people, and that the militia of the state was used for the same purpose, that the polls were surrounded by armed bands, who by violence and force prevented any exercise of the right of suffrage except on one side, in fact, that the election was controlled by the armed forces of the state and nation, and a resort to all manner of brutality, violence, and cruelty, and was not free. The majority of the Commission refused to admit the evidence, on grounds that would fairly warrant a President of the United States in using the whole army to take possession of all the ballot boxes in any state, and allow no voting except for himself if he was a candidate for re-election, or for his party, and which would require both houses of Congress to recount the vote so obtained, and to give him the fruits of such a willful and wicked violation of all constitutional law and right. If any decision better calculated to destroy the liberty of a free people, to destroy all faith in a republican form of government, a government of the people by the people, could be devised and contrived, the undersigned have not been able to discover it. They denounced the decision as an outrage upon the rights of all the people, and, if sustained, and acted on, as the utter ruin of our institutions and government. The foregoing is a brief statement of the action of the Commission. To defeat that action the undersigned have done all in their power. They protest against it before it was accomplished, and they protest against it now. They know the Commission was established to receive the evidence, not to shut it out. They know the conscience of this great people was troubled by fear that anyone should obtain the high office of President by fraud, cheating, and conspiracy, and that it demanded that the charges and countercharges of corrupt practices in reference to the election in 3 states should be honestly investigated and inquired into, not established and sanctified, by refusing all inquiry and examination. They know the conscience of the whole people approved the law establishing the Commission, nay, hailed it with joy, because it established, as all believed, a fair tribunal, to examine, to inquire into, and determine the charges of fraud and corruption in the election of 3 states, and they believe that this conscience has been terribly disappointed and shocked by the action of the Commission, which establishes fraud and legalizes its perpetration, instead of inquiring into and condemning it. The undersigned believe the action of the majority of the Commission to be wrong, dangerous, nay, ruinous in its consequences and effects. It tends to destroy the rights and liberties of the states and United States and the people thereof, because by it states may be robbed of their votes for president with impunity, and the people of the United States have foisted upon them a chief magistrate, not by their own free choice honestly expressed, but by practices too foul to be tolerated in a gambling hell. By the action of the Commission the American people are commanded to submit to one as their chief magistrate one who was never elected by their votes, whose only title depends on fraud, corruption, and conspiracy. A person so holding that great office is a usurper. As much as a usurper as if he had signed and held it by military force, in either case, he equally holds against the consent of the people. Let the people rebuke and overrule the action of the Commission. The only hope of the country rests on this being done, and done speedily and effectually, so it may never become a precedent to sustain wrong and fraud in the future. It is the first and highest duty of all good citizens who love their country to right this foul wrong, as soon as it may be done under the Constitution and laws. Let it be done so thoroughly, so signally, so effectually, that no encouragement shall be given to put a second time so foul a blot on our nation escutcheon. President Hay was nicknamed by the people for stealing the presidency, your fraudulency, and old 7-8. He knew his party cheated and it's why he swore to only serve one term. End of Appendix A. Please share, like and subscribe. Thank you.